Hey everyone, welcome to another episode of Live with NORML. I'm JM Pedini, the Development Director for the National Organization for the Reform of Marijuana Laws. It's Wednesday, December 11th, and today we're going to do a special episode talking about federal marijuana rescheduling, that process, what's happened so far, and what we can expect to see in the future. Hey, take a quick second to drop a note in the comments. Let us know where you're watching from. Let me know if you have any questions. And we are going to, it's not Friday. Yes, I know it's not Friday. We are going to welcome our guest, NORML's Deputy Director, Paul Armentano. Paul.
Hello there, JM.
Hey. Hey to you. Hey.
I hope you're staying dry today.
Barely, first of all. Hey to Randy, different Randy, who's watching. Thanks for joining us today. We will get right down to it, Paul. Last Monday, a pre-trial hearing took place before the DEA's administrative law judge. And what can you tell us about that?
Sure. So if folks go back and remember when the DEA called for administrative hearings, the date they set for the hearing to commence was December 2nd. And while the trial itself did not begin on December 2nd, the judge in this case did hold a pretrial hearing on Monday. And this was an opportunity for legal counsel for all of the participants that are going to be participating in the rescheduling trial to go before the judge, provide dates for their availability for when they can either testify in person before this court or virtually before the court. And it was also an opportunity for legal counsel to ask questions of the judge, for the judge to ask questions to legal counsel. In some particular instances, there were questions with respect to what sort of testimony participants would be able to give during the trial, what sort of evidence they would be able to present. So, for instance, at one point, the judge ruled that patient testimonials, someone who simply wanted to participate and say, I'm a medical marijuana patient, I want to tell my story, that sort of testimony would not be permitted, that it would not be part of the trial. There was legal counsel for another participant who acknowledged that, hey, there were over 43,000 public comments that were submitted to DEA during the public comment period. The overwhelming majority of those favored removing marijuana from Schedule 1. Could we introduce those public comments into evidence, into the record? And once again, the judge said no, that would not be something that he would allow into the record. Probably, or in my opinion, the most interesting development out of Monday's pretrial hearing was that legal counsel for the federal government, or in this case, the DEA itself, went before the judge. And even though all parties who are participating in this rescheduling hearing were mandated to have turned in all of their evidence and their affidavits laying out their positions and what they would attest to in court, even though all of the parties were given a deadline by the judge to have this information turned in weeks ago, there was one particular party that did not get their documents turned in on time, and that was legal counsel for the DEA. They actually walked into this pretrial hearing on Monday having not turned in any evidence over to the court and hadn't provided really an outline as to what their proposed expert witnesses were going to say. So even though technically it is the DEA that is designated as the proponent of this proposed rule, we actually have no idea thus far whether the DEA is going to walk into that courtroom in 2025 and champion removing marijuana from Schedule 1, or whether they're going to walk into that courtroom and testify against removing marijuana from Schedule 1. Or perhaps they take no position at all. Again, it's still unknown because they're the only party that hasn't turned over the necessary evidence and documents to the judge. And as you can imagine, when their legal counsel was being asked about this issue on last Monday, they remained coy and still provided no further substantiation of where their position lies, other than acknowledging, yes, they were the proponents of the proposed called for these administrative law hearings. And DEA is the same agency that historically has opposed every other rescheduling petition to remove marijuana from Schedule 1. So we certainly know historically what their position has been. We have some idea through their most recent actions what their position might be this go around. But again, we still have nothing official because, believe it or not, their legal counsel walked in there on Monday, unlike the legal counsel for every other party, and said, "I'm sorry, Judge, the dog ate our homework."
Was that surprising to you? Have you seen the DEA act like that before?
In some ways, it wasn't surprising because you see this sort of government arrogance quite often, where in these sort of settings, the rules apply strictly to everybody else, but they don't seem to apply as strictly to the federal government. And in this case, they didn't. The judge gave them further wiggle room and gave them an extended date with which they have to turn over this necessary evidence and documents. But as a result of the DEA not proffering a position, their witnesses will be the only witnesses during this trial that will not be cross-examined, because again, they have not provided a stated position on the record as of yet.
That's remarkable.
It's somewhat mind-boggling.
Wow. Well, those are certainly a lot of developments from that hearing. Now, earlier this week, earlier this week, you posted a NORML blog about the schedule for the trial. Testimony is set to begin on January 22nd. Can you tell us a little bit about how you expect the trial is going to unfold?
Sure. So anyone who goes to the NORML website can get a sense of the how the judge, after he did talk to the legal counsel for all the participants, after he heard their availability, he did set a schedule for witness testimony. That witness testimony begins on Tuesday, January 22nd. The DEA's legal counsel and their witnesses will be the first in the courtroom. And then the judge has scheduled different participants' witnesses to testify on every successive day, Tuesdays, Wednesdays, and Thursdays, running all the way through the week of March 3rd. Right now, the tentative final date of testimony from witnesses would be March 6th. Now, there is the possibility that this timeline could be delayed. There are lawyers for certain parties who sought to be part of this hearing and were denied standing by the judge and believe that they have a legitimate claim that they should not have been denied and that they should, in fact, be part of this rescheduling trial. They have filed suit in district court asking the court to intervene. And if the court decides there's some validity to that claim, they could issue a stay, which would then postpone this entire timeline, arguably back many, many months. If there is no stay prior to January 22nd, then this is a pretty clear indication that this judge expects to hear from all the witnesses present, and he expects to wrap up the testimony part of this trial by the first or second week in March.
That's interesting. What do you think the likelihood is of, if you had to guess, do you think there's any likelihood that the stay will be granted by the district court?
You know, it's really hard to say I think that most of the parties involved who have been granted the ability to participate and their lawyers and the judge in this case all want to kind of get this moving. We're already over 2 years into this administrative process. Those parties, for the most part, seem like they're ready to go on those dates and they want to go and get this done and move forward. So again, that's not to say that there aren't some of those on the outside looking in of this process
Mhm.
who say, "Hey, look, I don't care if these folks are ready. We should we should have a seat at the table too, and we're going to try every avenue to get us a seat at the table, even if that means postponing these hearings many weeks or perhaps even many months." One thing I'll also mention is that all of the witnesses who will testify on these specific dates, they're going to be given 90 minutes if it's a single witness is testifying. In some cases, there's legal counsel representing a consolidation of witnesses. In that case, they get 120 minutes to testify before the judge. And then every legal party who's present who wishes to cross-examine that witness gets 20 minutes to do so. So the cross-examination process for every witness is arguably going to be far longer
Wow.
than the time with which they testify, because there's nearly a dozen or so lawyers that are representing participants, and they all have the opportunity, if they wish to cross-examine. Now, what I don't know is whether those lawyers need to be physically present in order to handle that cross-examination. If that was the case, or if that is the case, it makes an argument for all the legal parties for all of these groups to actually be present in Washington, D.C. during the course of this hearing for the period of almost 2 months,
Yeah.
which I'm sure for many folks is simply an impossibility from a scheduling standpoint and anything else. So it'll be really interesting to see how that element unfolds.
And just to clarify for people who are now just joining or who are curious and don't otherwise know, NORML did submit to participate. We were not selected, and we are not part of the.
Yes, we are not among the groups asking for a stay because we are not selected.
There we go. Get that on the record for everyone. So presumably the hearing's going to conclude in March.
The testimony, the witness testimony part of the hearing concludes in March, correct?
And once that happens, then is the next step to wait for a ruling from
Exactly. So then the judge is going to take however much time he feels he needs to take to review the transcripts of all the witness testimony, of all their answers on cross-examination, and to examine what is arguably going to be thousands of exhibits, which are mostly going to be evidentiary studies that all the parties have provided that represent the foundation for their testimony. So to be clear, none of these witnesses can walk into the hearing and begin testifying to facts or opinions about marijuana or marijuana policy that they have not already they have provided studies providing the foundation for, right? So the judge is going to review at least some of these exhibits. He's going to review the transcript, and that's going to take some time. It'll probably take weeks. It could potentially take months. There's going to be a lot of evidence to review here. And then when he is done with that review, he is going to issue a ruling. And in that ruling, he is either going to say, I concur with the proposed rule to remove marijuana from Schedule 1 and move it to Schedule 3, or he will say, I do not concur with the proposed rule, and I do not believe the rule should go through, and therefore marijuana should remain in Schedule 1. But as I've said before in these live streams and to other folks, that's not the end of the process. That's only the end of the administrative law hearing. After the judge issues this ruling, then the DEA, the agency itself, which is the final arbiter of this matter, they then have to issue a final ruling of their own. in the federal record.
Mhm.
And for all of those out there, I want to emphasize this point. The DEA's final rule does not have to concur with the judge's final ruling. So, in fact, you could have a scenario where Judge Mulrooney issues a finding of fact that says, I believe the proposed rule should go forward. And the DEA turns around as an agency and says, no, we're not going to do that. We're going to set your verdict aside. And for anyone who thinks that's an unlikely scenario, let me remind folks that that's exactly what happened when NORML filed an administrative petition many years ago that led to ALJ hearings in the mid 1980s. In 1988, the ALJ, the judge in that case, ruled in favor of removing marijuana from Schedule 1. And 2 years later, the head of the DEA at that time, John Lawn, set the verdict aside. So again, the judge's ruling is not the end of the process, and there is no timeline in place that says once Judge Mulrooney issues when the DEA has to issue their final rule. They could issue it weeks later. They could issue it months later. As we saw in the 1980s, they took nearly 2 years to issue their final rule. At that point, when the DEA finally issues its final rule, it's published in the Federal Register. At that time, there is one more final window, one more final timeline, but it's a set timeline. There is a 30-day window with which parties can contest through litigation the DEA's final rule. And you can damn well bet, however the DEA issues a final ruling on this issue, whether they support rescheduling or oppose it, my guess is parties will litigate during that 30-day window, in which case the final rule will not take effect until after the litigation is settled.
Excellent. So this, I want to say that there's a viewer, Weed Street 420, who says, just like Judge Young in '88, and that was coming in. That comment was coming in right as you were saying that. So
yes, and in referring to that decision, and again, that does mark the last time this issue was litigated before the DEA's ALJ. The ruling took place in 1988. The DEA set aside the ruling in 1990. NORML litigated during that 30-day window, opposing the DEA's decision to set aside Judge Young's decision. And that litigation did not resolve until 1994. So there was actually a 6-year window from the time the ALJ judge issued a finding of fact until the matter was resolved.
So we could be in for another long haul, just like that.
Again, we could be, or maybe not, because again, all we know at this point is that the DEA is the proponent of the proposed rule, but we don't know whether they support it or not. And they are seemingly going to great lengths to not let us in on the answer to that question.
Oh, that's wild. Hey, everyone who's watching, thanks for joining us. If you have any questions for Paul, be sure to drop those in the comments right now. But Paul, since you're here, let's go ahead and talk about.
Oh, let me mention one other thing for folks.
Okay.
I mentioned that the in-person witness testimony is going to begin on the 22nd. My understanding is all of these proceedings are going to be live streamed. So unlike in 1988, when this sort of took place in secret, unless you were physically there, in this case, the public can tune in and they can watch all of the day's proceedings. They can watch them either live as they unfold, or they're archived on YouTube, and theoretically folks could go back and watch them after the fact. So if you want to see how this unfolds, you can, and you don't have to travel to Washington, D.C. and try and get yourself a hotel on the same week as the presidential inauguration, which will be impossible, to try and actually attend these hearings in person.
So they did stream part of the pretrial hearing but it was only
Yes, and
part
then
of
it crashed.
yeah.
Let's hope
So
they
that
have better luck during the actual trial.
let yes, let's. I think we answer questions about rescheduling every week on this show, and so for people who are new, who've never heard us talk about it, can you give a rundown of what moving marijuana from Schedule 1 to Schedule 3 actually means, um, and as opposed to what we hear people think it means?
Sure. So, there's a lot that it means from a tangible sense. There's many things it means symbolically. There's things it means in the short term, and there are things that likely will lead to in the long term. So it's actually quite a complex issue. What it doesn't do is it doesn't legalize marijuana nationwide, and it also doesn't rectify the existing conflict that exists between the majority of states that currently regulate marijuana, whether for adult use or medical use, within the confines of their states. It doesn't rectify those policies with federal law. Those policies right now are out of step with the way the federal government treats marijuana as a Schedule 1 controlled substance. But unfortunately, those policies will be also out of step with the way the federal government regulates Schedule 3 substances like ketamine. So it doesn't address what I would consider to be the biggest elephant in the room. It does make some changes that will be immediate. One of which, for the first time in modern history, will have the federal government acknowledging that marijuana is a medicine and that marijuana has acceptable use. That to me is a really big deal because I've been doing this work long enough, and I know you have too, JM, where I remember when the federal government didn't only deny marijuana was a medicine, but that they actually prosecuted physicians who tried to abide by state law and recommend marijuana to their patients. And they attacked dispensaries and closed them down. And they went after and prosecuted patients. So that would be a seismic shift in the federal government's position. Moving marijuana to Schedule 3 also removes the existing federal barriers that restrict the advertising of marijuana products. Now, in many cases, there's state and local laws that either restrict or allow advertising, but federally, advertising would be permitted. It would create tax breaks and incentives that the state legal industry and businesses right now cannot take, that force them to have much tighter margins than they otherwise would. Those costs generally get passed on to the consumer in higher prices. So theoretically, a move to Schedule 3 would lead to lower consumer prices. It's very possible that a move to Schedule 3 will finally allow the District of Columbia to formally regulate a marijuana market, which they've been unable to do thus far. And I think in the long run, you're going to see a lot of changes in regulatory policy that will occur after a move of marijuana to Schedule 3. For instance, right now, as many folks know, federal law defines all marijuana use as abuse. That's why under the 1968 federal gun law, a person who uses marijuana technically right now is a felon federally if they possess and own a firearm, because the law says a marijuana abuser cannot own a firearm. If marijuana is no longer in Schedule 1, that definition of the idea that all marijuana use is abuse goes away. And I think also that prohibition on firearm ownership goes away. It's very possible that change would have implications for federal drug testing and jobs and background checks. It's very possible it could have ramifications for even medical marijuana being reimbursed by insurance. It would definitely have ramifications for the federal restrictions that right now you can't be in federal housing and use a Schedule 1 drug because marijuana will no longer be Schedule 1. So I think there's a lot of changes on the margins, but changes that in fact will impact lots of consumers and people who use marijuana, both adults and patients, that will come out of a shift to Schedule 3. But obviously, we seek, and NORML's been very vocal in the fact that we ultimately seek marijuana to be removed from the Controlled Substances Act altogether in a manner similar to alcohol and tobacco, thereby allowing states to be the primary arbiters of their own marijuana policies, not the federal government.
I have two more points that are generally confusing for folks around rescheduling that I want to talk about. But since you brought up descheduling, I do want to take this moment to reiterate, I know you will agree, this is not an either or. We can and should be using both processes available for this. The descheduling process or rescheduling process review is underway, and that is its own thing. And then
correct. And the proposed rule is very specific. It's about moving to Schedule 3 or not. It's not about entertaining other options. And I would also mention that when we talk about descheduling, removing cannabis from the Controlled Substances Act altogether, that's really not an avenue for the administrative petition process. That's a legislative fix, which means it needs to be enacted by Congress. When the federal government repealed alcohol prohibition almost a century ago, it was done by an act of the federal government. When hemp was descheduled, removed from the Controlled Substances Act in 2018, it was done by an act of Congress. It wasn't done by the DEA. It wasn't done by the administrative petition process.
Right. So this is not the president doesn't come in and issue an executive order and legalize marijuana nationwide, as we say week after week after week. And to everyone watching, let's go ahead. It bears repeating. It requires an act of Congress in order to remove marijuana from the Federal Controlled Substances Act and allow states to set their own policies without threat of federal interference. And that's on you. That's on each and every one of you who is a voter. If you continue to elect people to Congress who will not bring forth that bill for a vote, we're not going to get anywhere.
And let's be clear, JM. This isn't a theoretical. When we talk about lawmakers need to bring forward a bill in Congress to deschedule marijuana, this isn't theoretical. No. We've had on 2 occasions in recent memory a majority of the House of Representatives pass such a bill to deschedule marijuana. Now, that bill was never advanced or even taken up in the Senate, but there is precedent for one of the 2 bodies of our federal government within the last 5 years passing legislation that says we're going to take marijuana out of the Controlled Substances Act altogether.
Yep. So everyone, please remember that next time you're stepping up to the ballot box, or if you're even considering if you should go vote. The answer is always yes, by the way, and we'll always tell you who to vote for in our voter guide, Smoke the Vote. Paul, 2 other points that I want to talk about rescheduling. This is, of course, specific to botanical cannabis. And we hear a lot of people talking about, oh, well, this just hands it over to big pharma. What do you think about that idea?
I thought someone would have to walk me through the logic of how they get there, because the reality is, first of all, big pharma already works with cannabis and cannabis products and is involved in pharmaceutical development of cannabis products. There already are FDA-approved drugs derived from cannabis. There's even one FDA-approved drug that's derived from botanical cannabis. So that pathway exists already. That pathway is arguably somewhat difficult for that industry when cannabis is Schedule 1. Doesn't particularly get any easier if cannabis is Schedule 3. And in fact, arguably, the only way that pathway gets easy is if marijuana is descheduled altogether, which would then eliminate the restrictions that are currently in place that provide hurdles for pharmaceutical development of botanical cannabis. And I think we're all in agreement, warts and all, that we do want descheduling. So let's be clear, a move to Schedule 3 is not going to only designate marijuana as a medicine. It's not going to put botanical cannabis in drugstores. In fact, when one reads the Office of Legal Counsel opinion that was published this spring about the recommended rule, they were explicitly clear that rescheduling marijuana under this petition and moving it to 3 would not equate to FDA approval. And absent FDA approval, or only through FDA approval, do we have the process where drugs are regulated or controlled substances are regulated in pharmacies and only available from prescriptions by doctors, and thus so on and so forth.
Right. So the FDA is not in a position to begin regulating botanical cannabis. They don't regulate plants, as
Correct.
you've said repeatedly. So this is not going to mean that you're going to get pre-rolls at CVS with a prescription. And likewise, it doesn't deconstruct every state regulatory structure and
Correct.
hand it over to big pharma, which we hear over and over again. I'm so glad we're doing this show to clear all of that up. And then one more point is about research. We hear people say, "Oh, this is gonna make research easier."
Yeah, probably not. It's funny. I did an interview with NPR earlier today, and the reporter said that very thing to me, and I said, well, I'd like to correct you on that. So this is a really complicated issue, and it's often oversimplified in when it's discussed. But when we're talking about research, that's such a broad term. In this context, we are talking about clinical trials. And in a clinical trial, researchers seek to provide marijuana to patients and to see what the outcomes of their use of marijuana is. It's only doing that kind of research, that sort of clinical trial work, where there are hurdles in place federally that make conducting that research more difficult than it ought to be. Now, that research is conducted, and it's conducted in the United States. In fact, the United States is the world leader in cannabis research around the globe. But there are hurdles in place that make conducting that research more difficult than it ought to be. One of the primary hurdles is the fact that scientists, if they get such a protocol approved, they can only supply patients or participants in their trial with marijuana that's been grown under a federal license. And there are very, very few federal licensees that have permission to grow cannabis. And frankly, most scientists, they don't really care what the effects of federal government grown cannabis are. They want to know what the effects of state legal cannabis products are. But right now, you can't do that. That restriction is not due to cannabis being Schedule 1. That restriction exists because in 1967, prior to the Controlled Substances Act even existing, the federal government put that restriction in place, and it's remained in place all this time. Moving marijuana from Schedule 1 to Schedule 3 does not eliminate that restriction. Congress could, once again, the usual suspects, they could fix this by amending the law, but they've chosen not to do so for 55 plus years. But the fact is, just moving marijuana from 1 to 3 probably isn't going to change very much when it comes to clinical research. Frankly, the other thing that would really kickstart clinical research is somebody being in charge of HHS or NIDA or one of these agencies saying this sort of research is a priority, and it's such a priority, we're going to fund it with a large sum of money. That's the other way to get this sort of thing kickstarted. And perhaps that might happen under the new administration and the new shakeups at HHS. It's not beyond the realm of possibility. But at the end of the day, and JM, you've heard me say this all the time, it's not that we need more research. We already have ample research to establish that cannabis is in fact an accepted medicine and is in fact safe and effective, and that it has a superior safety profile to many prescription drugs and most other recreational intoxicants. That information is already there. It's not that we have a knowledge gap. The problem has always been the law is not consistent with what the science tells us about cannabis.
Absolutely, Paul. I have also heard from scientists in labs who have, on the research point, have said, well, if it is moved to Schedule 3, then it would be slightly easier for researchers in labs who are looking to get a DEA license, where they may not need to apply for a Schedule 1 license, which is very labor intensive. And they could instead apply for
And,
a
and,
Schedule
and
3
it
license.
also has implications that I mentioned this in some of my other talks. I didn't mention it earlier. The move to Schedule 3 could very well have implications for state testing labs. Right now, there's not that many of them that in legal states test cannabis products for potency, purity, and so forth. I certainly think there needs to be more. I think the labs that do exist need to be better regulated. But one of the reasons so few labs are hesitant to do this is because it's Schedule 1 in the licensing requirements. And I do think you would see more folks get involved in the lab testing side of the state legal product industry under rescheduling. And I think that's a very good thing for consumers.
Absolutely. Setting up a lab is difficult from the application process, from the cost of the license, the cost of all the equipment, and lab shopping remains a real issue in the cannabis industry across the country. Or to your point, just a lack of labs. There may be only one or two in the state.
Right.
And that's what you get. I can tell you that's what we have in Virginia. You get what you get, and you hope they're doing a good job. I know that some people you and I know are developing some protocols around this, and I hope that those are widely adopted soon, so that we do have better testing across the country for cannabis consumers. All right, Paul. What did we miss? Do we need anything else to button up the rescheduling
Well, I
conversation?
think Weed Street 420's got I think a
Oh,
good
yes.
question.
Thank you. Let's show the question.
He mentions that when the proposed rule was first publicized, that the DEA did not sign off on it. And historically, the DEA has. This is really their bailiwick. And instead, the Attorney General, Merrick Garland, signed off on it. And there was certainly a lot of speculation at the time when that happened that the DEA didn't sign off on it because they really weren't on board with the proposed rule. And Merrick Garland sort of went above their head. I think that's probably right. I think that's probably a correct interpretation of what happened. So this person's asking that, hey, if Pam Bondi is confirmed to be the next attorney general, would she take a similar position if the DEA seems to be reticent to move on this issue? And I think the answer is we don't know. We have a little bit of knowledge of Pam Bondi's record as Florida AG. She is really, she's a pretty conventional law and order type. There's really nothing in her record to show or establish she would have any sympathy toward this issue. But at the end of the day, she's also a Trump loyalist, which is why she's been nominated. And the fact is, if this is something Donald Trump or his administration cares about, and I don't know if it is or not, but if it is, and he makes it clear to her that it is, I don't believe she'll stand in the way. I believe she'll go in lockstep with what he wants. Certainly during the campaign, Trump did indicate that he favors rescheduling. And if that's true, I can't believe he would allow his AG to stand in the way of it. Even if she had personal feelings and desires to do so, I think he'd tell her to get in line, and I believe Pam Bondi would.
Well, let's all hope that the incoming administration and perhaps president have, in fact, taken a look at the documents that we provided regarding potential cannabis policy reforms and during the next administration.
Correct. And if folks want to learn more about what JM's alluding to, there's a Marijuana Moment story that was published earlier this week. NORML and MPP sent a joint memorandum to some of our connections in the incoming administration, essentially with a laundry list of actions that we believe they could take administratively within the first few days of taking office that would bring some relief to marijuana consumers and bring some potential positive changes in federal marijuana policy.
I am going to, oh, no, I'm not. That's interesting. I'm going to share that Marijuana Moment story in the comments As soon as it comes up. I'd say you could go read it on Facebook, but Facebook's got some issues today. Otherwise, you can take a look at it there. I have someone who made a comment that I assume is supposed to be comical, Paul, but while I look for this article on Marijuana Moment, I'm going to share the comment, and then if you would be so kind as to at least read the part you're answering, so that anyone who's just listening to this knows what the question is.
Yeah, absolutely. You know, I just spoke about this issue at our Key West legal conference last week, but this notion that the marijuana today is somehow fundamentally different than the marijuana of yesteryear, it's only a compelling argument if you have no sense of history or any sense of context. The claims that the marijuana of just this generation is exponentially stronger and therefore more dangerous than the marijuana of previous generations actually has been recycled every single decade throughout the history of prohibition, going back to the 1930s. And if one is actually would do the math, that would make the marijuana of today in the realm of thousands and thousands of times more powerful than it was in the past. It would be something like 25,000% THC, which of course is impossible. And the entire argument is largely rhetorical. It's literally the purpose of the argument is to try to get folks who in their own personal history have experience with the use of cannabis, did not find that experience to be problematic. It is an effort to get those folks who may not be using cannabis anymore to try to convince them that their own personal experience is somehow no longer relevant to the experience today because cannabis is a whole new drug. But at the end of the day, cannabis is cannabis. It's fundamentally the same substance that was incapable of causing lethal overdose 30, 40, 50 years ago, that's also incapable of causing lethal overdose today.
It doesn't seem to be working, this this claim either, Paul, with the level that public support has risen to. It just doesn't seem to. It's exponentially more powerful than the public support of your grandmother's day.
Exactly.
So thank you to everyone who has offered some comments. You all are very entertaining. Thank you, Weed Street, for your question about Pam Bondi. That was great. And if you are watching afterward, you're welcome to send us an email at normal@normal.org, and we'll do our best to get you an answer. Thanks to everyone who joined us for today's show. Thank you, Paul, for taking time out of your afternoon to be with us today. And
happy to be here. Love interacting with our audience and answering questions, and I look forward to us doing this again sometime soon.
Yeah, we definitely will. Let's all say goodbye to Paul, and I'm going to do a little wrap up. Bye, Paul.
Bye-bye.
All right, friends, we have another Live with Normal regular weekly update scheduled for Friday, December 13th at 4 p.m. Eastern Time. So please mark your calendars, come back and join us again. I'll be answering all of your burning questions live and recapping this week's cannabis policy and science news. I love hanging out with you all on Fridays, so please be sure to join us back here on Friday. And as always, you all have a fantastic afternoon. I'll see you right back here next time. Bye-bye.